Okay, over to you, Professor McAlevey.
Great, thank you very much, Libby. Well, hello, everybody. It's great to be back online. I've just returned from several trips to Africa when I've had the great pleasure of meeting many of the participants in this year's mooting competition, and I was able to do some mooting training in Lagos and actually to run some of the internal competitions whilst I was in Kenya, and I was really impressed with the standards. So everything bodes super well for the international competition coming up in just a few weeks' time. So do encourage you to connect with Libby so we can arrange the times and the scheduling for the international competition. So today, the team have got the second in the preparatory seminars for the international competition, and Kelsey and the team are going to be taking you through the respondent's position. So without further ado, let me pass over to Kelsey and the team for this afternoon's presentation. Kelsey.
Good afternoon, everyone. I hope everyone's well and enjoyed the appellant seminar last week. We're going to build on a few of the legal issues we touched on and kind of angle them more in terms of how you would argue them in terms of the respondent. As the respondents aren't provided with grounds to argue like the appellants are, it's very important that you kind of pay attention to what this lecture says, because it will tell you how to rephrase the grounds of appeal to sort of respond to them, that the respondents will need to do. So I think Ria is starting off today's lecture, but if you have any questions, please put them in the chat. We'll just pick them up as they come in, and then there'll be time for more questions at the end. So.
Hi, everyone. So we're just going to get started with a little recap on the rules of the international competition in the first instance. This is similar to the information that we provided last week. We just wanted to go over it again because it's really important information. So each team will be mooting twice for both sides in the competition, the appellant and the respondent. And ideally, you're wanting to only use cases and judgments that are provided within the judgment pack. Each mooter will be speaking for 7 minutes, and that includes any judicial intervention. And you aren't required for this moot to make a skeleton argument or a bundle. If you could just instead direct the judges that you have to the judgment pack that we've provided with page numbers, that would be perfect. And the order of speaking will be the junior appellant, then the junior respondent, and then senior appellant and senior respondent. So just to go a little bit over the criteria we're going to be using to mark, each moot will be scored out of 100, and the criteria will be focused on oral presentation, so that's kind of your style of speaking, your legal argument, so which cases you've chosen to use and which quotes and how you're using those to build a legal argument, your response to questioning, so that'll be if we ask you, for example, if a case is binding or persuasive, whether you answer that correctly, and if you can give the court that it's in, that'd be even better. And then courtroom manner, if you're using the my lady, your ladyship, and equivalents. We also mark as well for teamwork. So if it's clear that you've both prepared together and there's like an overall line of argument across the both of you, and overall presentation as well as a pair. So just to have a quick recap on the main points of the moot problem, the two parties are, for the appellants, it is Hot Wheels Garages Limited, and then for the respondents, it's Lewis von Speed. So the role of the respondent is to respond to the grounds of appeal that are made by the appellant and then submit why the judge should dismiss the appeal. So that's always a really great line to have at the end of the conclusion as well, is that we ask the court to dismiss the appeal. So the junior respondent should introduce the grounds of response and kind of outline them for the judge and what points the respondents will be covering, and then cover that first ground of response that you've made. And the senior respondent would then submit the other ground of response and conclude the submission, just like a brief conclusion on both grounds. So covering what your junior has said, as long as what you've said. And then both the junior and the senior should be engaging in a bit of rebuttal to submissions made by the appellant, because the order of speaking is specifically designed so that everyone has greatest chance possible for rebuttal, and it'd be really good for your marking as well. So in particular, different to the appellants, respondents don't need to introduce themselves because the junior appellant should, at the start of the moot, introduce all of the mooters to the judge, and the respondents also don't have to offer the facts of the present case to the judge as well, because that will also have been offered by the junior appellant. If you are wanting to offer facts of like particular cases that you are using in the judgment pack, you'd be able to offer that to the judge as well. Professor Peter?
Great, thank you. Sorry, just to jump in. Thinking about some of the things that I heard on the practice competitions that I did, completely reiterate everything that you said, Ria, but also for all mooters to remember, you must be listening to what happens in the earlier moots, in the earlier presentations. So, for example, if you're presenting the same case as your opponent has presented, and your opponent has begun by saying, "My lord, can I take you to the facts of the case?" And if the judge says, "No, I'm acquainted with the facts, I don't need to have them," well then, as the respondent, you should not be asking the same questions. Does my lord, my lady wish to be acquainted with the facts? That's already been answered, so don't say that again. So just sort of an ask. You always got to show you're attentive and that you're reacting to what's happening in your own mood, so you don't sort of repeat things unnecessarily. That's it. Thanks, Ria.
I definitely agree that that's super important, and it'd be good for your marking as well to show the judges that everyone is listening to previous submissions. So we have gotten a question in the Q&A box here, and someone's asked whether they'll be provided with the names of opponents before the moot. So where possible, what we did for the internal competition was to have people change their names online as written as junior appellant or senior appellant or junior or senior respondent, just for the aid of both us when we're marking and also for the junior appellant to be able to write down all of the names of the people speaking. So, and if that isn't done for any reason, do just ask before we start the moot. And if you're unsure about how to address your judges as well, all of these things can only help you. So we're happy to answer those sorts of questions just before the moot begins.
I will just add, I will, where possible, send on advance notice, but sometimes these things can change in the moment. So I will also list that in the chat when we get into the competition, so you will have a written version of that as well.
So just a little bit about managing the workload as a team. You can focus separately on how you form your grounds of response, but there should be an understanding of both of them, just in case your judges do ask any questions. You're able to say something along the lines of, "Oh, my senior will be covering this further in our submission," or if you're asked something about your juniors already presented on, it's something you're able to say, "My junior presented this case, which covered that legal argument." And where possible, you're wanting to include a minimum of, I'd say, 2 cases from the judgment pack. Just because you've only got 7 minutes, that's probably the ideal amount to get in as much legal argument as you can as well. And team sizes will vary depending on the school. So you could have 4 members or 2 members, but when you're researching, try and make sure you utilize every member of the team that you've created. So to recap the facts of the case, Hot Wheels Garages placed an advert that repairs would be half price if a letter of acceptance was sent by Royal Mail by Tuesday, 14th of February. Lewis von Speed then sent a letter by courier about the repairs to his car and passed that letter on the evening of the 14th of February, but it didn't arrive until the 16th of February. During the repairs, one of the mechanics took the car onto the main road to test that those repairs were completed properly, and Mr. von Speed had only agreed to have the supercar being tested around the garage forecourt. And when returning, he negligently collided with a delivery truck, damaging the car. So Hot Wheels Garages denied liability, stating that Aaron was acting on a frolic of his own and charged Mr. von Speed full price for the repairs. Mr. von Speed then issued proceedings for damages and half the price of the repairs, and the High Court in the Queen's Bench Division ruled in favour of Mr. von Speed.
Hi, everyone. So I'll be covering the grounds of appeal. So as we discussed last week, just a second, the grounds of appeal are that the Justice Mansell, the judge that ruled in the first instance, ruled that Aaron was acting not in the course of his employment. Instead, Aaron was acting on a frolic of his own, and Hot Wheels Garage was not liable for the damages to Mr. Von Speed's supercar. The second ground of appeal is that Mr. Justice Mansell also erred in ruling that the postal rule applied. The advert clearly stated that the acceptance to the offer must be sent through the Royal Mail, and Mr. Von Speed was not entitled to pay half the price, because as Ria stated by the facts of the case, he sent the acceptance by the courier. So as the respondents, your role is to be analytical in the grounds of response. Basically, what you will need to do is argue the opposite of the grounds of appeal. So it is advised to you that you begin with looking at the decision of the lower court to argue why the judge at first instance was actually correct in their decision and base their argument on this ruling. If you want to add your own flair to the grounds of response, you can ask your tutors in the one-to-one sessions that you can schedule. So the examples of your grounds of response would be that Mr. Justice Mansell was actually correct in ruling that Aaron was acting in the course of his employment, and that Hot Wheels Garage, his employer, was liable for the damage that he caused. That would be vicarious liability. It is something that we discussed last week. The second ground of response would be that the postal rule should be applied to Von Speed's letter and that he was entitled to pay only the half of the price of the original repairs. So looking at the legal issues, the first one is the liability for damage to the car. The respondent's role will be to argue that Hot Wheels Garage is vicariously liable for Aaron's actions. As we spoke last week, just to recap, when the Hot Wheels Garage is vicariously liable, that basically means that they're taking financial responsibility for the actions of their employees. The respondent will argue that Aaron's actions were within the scope of his employment, and the rule of law which imposes strict liability on employers for wrongdoings of their employees would actually apply. So just to clarify here, the part of strict liability, what is meant by strict liability is that the employer's intentions do not really matter. So in vicarious liability, employer himself might not be responsible for the actions that his employee has done, but strict liability basically means that their intentions don't matter and they have to be responsible basically for their employees. Therefore, it can be argued that Aaron was permitted to drive the vehicle and that his actions were in the course of his employing. The good tip here is when explaining vicarious liability, you can repeat the definition of what it is, but it is always a good idea to find a case that explains vicarious liability, and that just helps you to make your argument much more reliable, that you're relying on the case law and not just the slides, for example. So the fact that the act committed was prohibited cannot on its own exclude vicarious liability for the employer. If you can show that action was still closely connected to the aim and duties of Aaron's employment, then vicarious liability will be imposed. So the good thing to think about here is, for example, would other car mechanics test the car, for example, on the main road? If you can argue that they can, then that's going to be, well, basically your argument that he was acting in the course of his employment, and the prohibition part is not the crucial deal breaker kind of in this argument. So the second legal issue after vicarious liability is offer and acceptance. And here we're going to be talking about postal rule again. So that's the same rule that you guys were mooting on in your first internal competition. Postal rule is an exception to the rule that the acceptance must be communicated to the offerer. Basically, your acceptance will be valid as soon as you post your letter. And it doesn't matter if it reaches the offeror, for example. The postal rule was first discussed in Adams and Lindsell. A lot of you already are familiar with the case because you mentioned it in your internal mood. And as you all know, there are exceptions to the rule. There might be some tweaks, for example, saying that the said option shall be exercised by notice in writing too, meaning that the acceptance must reach the offeror. So as the respondents, it would be a good idea to find differences, so to distinguish the case which created this authority from the case of Louis von Speed. So you must address whether Mr. von Speed's decision to post his letter by courier instead of Royal Mail was still valid as a postal rule. It is permissible under the postal rule to use an equally effective form of communication provided if it does not disadvantage the offeror. So you can argue that actually sometimes letters sent by courier are faster, and it definitely would not disadvantage the offerer, for example. And again, look at the facts of the case, when the letter was posted by the courier and when did it arrive with Hot Wheels Garage. How to argue the grounds of response. So here are some general tips for you. As the respondents, you must support your ground with legal authority and check if the authority is binding on the court. So whenever you are referring to a case or legislation, especially the case, just keep in mind in what court the case was heard in and whether this court is of equal standing or of higher standing than the court we are in. So there is a usual question that judges ask is the case that you're referring to binding on a court today? So it's a very easy way to kind of get some good points. Just have it written down somewhere near on notes of your submission where the case was heard. And if you can say that, yes, it is binding because it was heard in House of Lords, that would just be a perfect response. So remember that the case is being heard in the Court of Appeal. And again, if you mention cases, it's always a good idea to mention cases from Court of Appeal or Supreme Court. Just a reminder, there are also cases from Privy Council. And if you're asked whether cases of Privy Council are binding, you can say that they're highly persuasive. So all relevant cases are found in the judgment pack, and we strongly advise you guys to use judgment pack. Try not to refer to some external sources, especially something like statistic that you can find on Google, anything like that. That is just not really helping your case. And every time you use a quote from the case, try explaining why it applies to your present case. So try avoiding just throwing quotes at judges. You should just explain why those quotes in those cases really support your argument. And I will pass on to Kelsey if no one has any questions.
No, I don't think we've got any questions coming in yet, but there's still time, guys. I know that maybe vicarious liability is a new thing that a lot of you will be learning. So if you do have any questions, please just ask us. And just to kind of put it out there, it is a secondary form of liability. We spoke about that last week. So it won't take away from any of kind of Aaron's personal liability to Louis von Speed. It's just that Louis von Speed is able to go against Aaron as well as his employer. That's just how it works. Okay, so moving on to rebuttal. This is, I think every judge kind of treats rebuttal quite differently. And some people as well like to do the rebuttal right at the beginning. So if you start in your speech, it's usually not the junior appellant that does any rebuttal, because you kind of need to hear what the other side says first. So usually the junior respondent will be the first person to engage in rebuttal because they've heard what the appellant has said. And that's why it's really important for you to listen to what the other mooters are saying and not just focus on what your speech is going to be and what your argument is going to be. And it's just important to kind of put in a few little sentences here and there that kind of show that you have been listening to what the other side has said and you're trying to reinforce a point in your own speech to counteract that. So some people like to do their rebuttal at the beginning and set it out there. Other people just like to do it throughout their submission, and either is fine, really, but it might be slightly clearer if you do it at the beginning, but it's entirely up to you. So essentially what this means is it gives you the opportunity to weaken and criticize the other side's submissions. So they may be using a case that isn't as persuasive as a case that you're using is, or they've maybe misinterpreted an area of law, or you think that a point that they've made isn't as strong as a point that you've made, and you just want to say to the judge, my lord, while the appellants have submitted this, we submit this, and your lordship should consider this in making your final decision, something like that. So there's just an example here. If the appellants make an argument relating to vicarious liability, which the respondents do not believe applies to the case, they should take the opportunity to engage in this rebuttal. And you still have to be professional and courteous. You can't say that they are wrong or that they've you can't kind of insult them, if that makes sense. Please do try to keep it very professional, and you should use phrases like, well, my learned friends across the bar have argued this and this, or my learned friends across the bar have submitted this case or relied on this authority. It is respectfully submitted by the respondents that that case is not as binding as this case. So it's more about kind of making sure you're reinforcing your argument rather than tearing theirs down, if that makes sense. But we have seen some people do rebuttal in the internal competition, and I think it was very well handled. No one was disrespectful, so keep that up, guys. And there's just a quote here about make sure to leave a little time in your speech for rebuttal. Not a huge amount. And as I said, it depends whether you would prefer to do it at the beginning and kind of cover all the points that the appellants have made and kind of oppose them, or whether you'd rather do it throughout your speech. I lean towards the second. So naturally, there will be sentences or points in my submission which will reflect those referred to by the appellants. So I will usually just add a sentence to say, for example, if I'm citing a case and I was saying at the end after I cited it that this is a binding authority, I would maybe take a second to just write a sentence in there that says, this contrast to the case that my learned friends across the bar have cited, which is not binding on the court today, and your lordship should consider this. So just things like that. You're just adding like a sentence or two here or there just to reinforce your arguments to the judge, and it shows them that you've been listening and engaging on what the other mooters have said. Okay, and in terms of judicial intervention, this is probably what mooters hate the most, but it's really an opportunity for you to stand out to the judge. If someone handles judicial intervention really confidently, then you're almost always going to score a really high mark, because it shows the judge that you're willing to engage with them in the questions that they have, and you can do so in a professional manner, in a confident manner, and be able to provide them with a correct answer to their question. We just have a small Q&A.
It's just about whether or not it's appropriate to say we'd like to reserve 1 to 2 minutes for rebuttal, as a preamble, or when you start.
Yeah, I mean, that's how some people do it to the judge when they say at the beginning. They would say, my lord, before making the respondent submissions, we would like to spend some time rebutting points made by my learned friends across the bar. That's completely fine to say something like that. But as I said, it depends what your style is, whether you'd like to do it at the beginning or whether you'd like to just do your submission and put it in. Because if you're making, we had this recently in a moot, where if you're making rebuttal first, obviously you have been writing it, or most of it at the time you've been listening, so it can feel a little less confident than the rest of your submission maybe. So it depends if you'd rather have a really confident start with your own speech rather than trying to make these points almost kind of on the fly. So it's up to you, but that is completely acceptable. Back to judicial intervention. So a lot of questions that we will ask will be referring to cases. So why have you used a certain case? Is it binding on the court today? And where the case was heard, so which court it was heard in. I said this last week as well. If you know the answers to kind of those questions, you're pretty much going to be able to answer 90% of the questions that the judge will ask you. We might also ask you some questions about, for example, a point raised by the other side. We may ask you to respond to that if you haven't already, and things like that. And there isn't one right answer, but the most important things is that you say your answer slowly and confidently. And yeah, it's not so much that there is a right answer that we're looking for, but if you can come out with a coherent response, something that makes sense, something that is justified in a very polite manner, and don't slip into casual speak, then you'll be absolutely fine. And don't forget that if the judge asks you a question that you don't understand, you can ask them to rephrase it, and that might just give you a few seconds of thinking time. That is crucial. And don't be afraid to take a pause when you've been asked a question. You can have a drink if you've got water next to you, or you can just take a second. And I promise you it won't feel as long to the judge as it feels in your own head, but you can just take a few seconds to think about what your answer is. And a lot of judges prefer that, because then they can see that counsel is actually trying to think about what the judge has asked and how it relates to their submission, and come up with a confident answer. And yeah, just remember that the judge is not trying to catch you out. We are just trying to test your understanding. We do have a part of the marking that is for judicial intervention. So it is important that we ask you at least one question, if not more. And just to warn you that if you are severely under time, we might ask you a lot of questions at the end to fill the 7 minutes. So always try to make sure that your speech is around 6 to 7 minutes. Okay, terminology. We have gone over a lot of these last week, but we haven't commented on them quite so much this week. So just to kind of go over some of the more complicated ones. To distinguish a case means when you're saying there's potentially a binding authority that the other side is using, but you're arguing that the facts don't fit, or the legal principle is not quite the same in this instance. So you're essentially asking the judge to recognize that that is a binding case, but you're asking him not to follow it or follow its reasoning in the present case. And the term we use for that is called distinguish. So you can invite the court to distinguish the case of, for example, Adams and Lindsell. Liability means to be responsible or answerable in law. It is essentially where someone has a duty to someone else and they've breached the duty, which leads to the other person having a remedy that they can seek through the court. And vicarious liability, as we spoke about, is the employer's liability for the wrongdoings of their employees. And a frolic of one's own is a legal test, if you can believe it, which relates to looking at the actions of the employee, and even if they are during work hours, determining whether their actions were actually committed for their employment or they were just doing something else that they wanted to do. So that will be important when we look at Aaron's actions. Okay, and some recommended reading. I know not everyone has access to the textbooks, as we've been told, but if you do have access to either of these textbooks, it would be good to have a little read about what they are. And if not, the judgment pack has all the legal authorities you will need, and you are welcome to ask us any questions during the drop-in or the other workshops we'll be hosting, or just through WhatsApp or email. We're happy to answer any questions, but hopefully these slides and the slides from last week kind of give you everything you need to know about vicarious liability and the post-rule rule for the competition. And best of luck, guys. This is supposed to be fun, and hopefully you've all had a lot of fun in the internal competition. I know a few of you have been having live ones, not online, with Professor Peter, so hopefully those have been great as well. It will give you a lot of beneficial experience if you go on to do kind kind of in-person mooting competitions in the future, because it's very different from doing it over Zoom. But they each have their own kind of benefits and drawbacks. But hopefully everyone is looking forward to the international competition and is excited to get started.
I'll just, if it's okay, we open the floor to questions. So please do either put your questions in the Q&A, or if you want to, you can raise a hand and we'll unmute you. And you can ask your question in person. Whilst you're thinking about questions, a quick recap from me about the international competition. So the international competition will take place 2 weeks in March. It will start on March the 11th. So week beginning March the 11th and then week beginning March the 18th. Those will be the 2 weeks for the international competition. Can I have a plea, please, to all schools to pass on as many available dates and times that you have, and if it's possible to list those times in UK time or Greenwich Mean Time, GMT, then that's really helpful for me, because the UK is the common denominator in all of this competition. Otherwise, I'm dealing with multiple different time zones. So UK time, please. A quick note to say that we passed on the presentation for last week's seminar this week, but actually I've attached the wrong presentation for you. So just to let you know that I will be emailing you all this evening with both recordings for both the seminar last week and the seminar this week, and I will attach the correct presentations to the email. And I think that's me in terms of a quick update. We do have one question, and that's how do you frame the grounds of response? So Ria, you've said that you'd like to answer that question. So if you want to unmute yourself.
So with the grounds of response, you're wanting to frame those as almost a direct contradiction to what the appellants have presented their grounds as. So if there are any words in the grounds of appeal that you can change to make the opposite into a grounds of response. So if, for example, one is the judge erred in ruling this, as a respondent, you're wanting to say the judge at first instance was correct in ruling this. And it's just trying to swap around the grounds of appeal that you've been given to suit the argument that you're going to be making.
And I think as a team, because there'll be 4 of you and 2 of you will be arguing as counsel for the appellant and 2 as counsel for the respondent, really good if you can work together on that and practice as well, because that's the whole thing. So
yeah, it's not, you don't kind of need to be the most creative. We aren't looking for sort of out there grounds of response. It should just be that you're opposing what the appellants have said, and you've got the grounds of appeal, so you know that you need to argue the opposite. So as Ria said, just you can play around with a few words and switch a few words, and that will be completely fine.
Fantastic. I can't see any further questions coming in. As this is our final seminar, from the students, would you like to pass on any final top tips before the competition begins?
I'll go with a really easy one, which we say this every time: slow down. You honestly can't speak slow enough when you're delivering your submission. Although you have a nicely prepared speech that you're reading out to the judge, you have to remember that all we will be looking at is the judgment pack. So it's important that you deliver your presentation as slowly and as clearly as possible. We have had a few volume issues as well, so if you can speak nice and loud for us, that would help us as well, just to make sure that we can hear everything you're saying and can take it down and can understand it and then ask you questions at the end. But yeah, do try to time your speech beforehand, but if you think you're speaking slow, you can probably speak a bit slower. You will feel that you're going really slow, but it's really, really helpful to us.
And remember that I will be putting up time cards, so you will know when you've got 2 minutes left and 1 minute left, provided you are having regular eye contact, and watching the screen.
I'd probably say if there's any words that you're worried about getting wrong, or like specific legal words, like if you're going to pronounce a case, instead of saying v or versus, you're going to have to say and, just to write them straight into your submission like that, just so that you don't confuse yourself. And the same if you're addressing a judge, to always have a my L or your L in your in your speech, just so that as well you don't confuse whether you're saying my lady, your ladyship, or if it's a mixed panel of judges, and just that you have that ready to go. And then it always just gets you points for courtroom manner.
Yeah, I think I could just add, try not to skip on rebuttal. I remember myself in first year, I've been doing moot, and I thought, oh, that's just not necessary, I'll skip on that. But, you know, if you've ever seen any legal dramas, that's when the lawyers scream, objection. Obviously, we're not doing objection in the moot, but that is your way of doing the objection. So your way of objecting is incorporating rebuttal into your speech. So this is just your way of saying their argument is great, but ours is just a bit more correct. So I think try not to skip on rebuttal. It makes your submission much more sophisticated, and we always notice it.
And my top tip, it is if you are only doing one side, so if you're doing the appellants, don't think you can just forget about what the respondents are saying. You need to know the other side's case just as well as your own, because it's only if you know it super, super well that you'll be able to do, as Rihanna said, you'll be able to have the rebuttal at the tip of your tongue, ready to go. That you will fully appreciate the weaknesses of your case as well as the strengths, and you'll be able to sort of hone in on the weaknesses of the other side. So don't try and take a shortcut. Know the other side's case just as well as your own. And also, it will help you to test your teammates who are acting for the other side, and vice versa. They can help test you. So if your school is having two different students for the respondents, two different students for the appellants, make sure that each of those teams knows the other side's position just as well as their own. That will enable you to have a much, much stronger performance.
Fantastic. Well, thank you very much indeed. And we have no further questions. So we will wrap it up for today's proceedings. I will send on the recordings again for both last week's seminar and this week's seminar and the presentations today. And a final call, please, to get those times and dates to me just as soon as possible. But from us all in Dundee, we wish you well, and we are really looking forward to seeing you in the international competition.
Thank you. Best of luck. See you soon.